How y'all doing? Welcome back to stream number 3 for today. We've had a busy day. All right, so let me get the stream ready for you guys. Looks like they are seating the jury, or I read a while ago that they are seating the jury, so. As soon as they get the jury seated, we'll get started. Okay. All right. Welcome back, everybody. Thank you. Make sure to put your DNA on that thumbs up button. Do all the other YouTubey things, like, subscribe, all of the things. And we have memberships. Thank you so much, QB. We do have memberships. We have so many members now. You guys did the most. Welcome back, Henny and Tanika. She's warming up her coffee. Long time no see, right? Hello again, Billy. Hey, Susan. Patricia. Right. Gail. Patricia, I'm in agreement. It seems very overcharged to me. I love it, Laura. That's how. I love it. Welcome back, Shell Bell. Hello. Not yet, Tanika. I'm going to do that as soon as they get started. Welcome back, Margaret. Oh, thank you, Laura. You're so sweet. Thank you. I appreciate that, friend. Yay, Roomba didn't get stuck under the fridge. Good job, Roomba. Hey, Rogue. Rogue. So, do you remember? Sorry. Do you remember? Callie says, I'm not judge jumping, I'm channel. Do you mean hoeing or hopping? So, Rogue, this dude named Deobra Redden from Las Vegas area was in front of the judge, Judge Mary Kay something. I can't remember her last name. For show the tape. Yeah, right. Roll that beautiful bean footage. Okay. Does somebody want to send me that beautiful bean footage again? Because I don't have it accessible. QB, can you send it to me in Discord? Roll that beautiful bean footage. So there's beautiful bean footage of why he's on trial for attempted murder. Lord have mercy. Lord have mercy. Let me go to my Discord, see if I can find it. Do you remember? Bum-ba-dum-bum-bum. Do you remember? I'm looking. Stand by, said QB. Thank you, ma'am. If I open up any more tabs, my computer's just going to go on strike. It's going to jump over the desk at me if I pull up another tab. especially another YouTube tab. All right. So she's going to send me that. Thank you, ma'am. Thank you very, very much. Okay, hold on. All right. So let me share this tab real quick. This is Rogue, to answer your question. All right. Watch this.
On January 3rd of this year, Deobra Redden leapt and tackled Judge Mary Kay Holthus. He was in court for sentencing for a probation violation connected to an attempted battery charge, which stemmed from allegations that he had attacked somebody with a baseball bat the year before. Moments before.
Right. I'm going to rewind it and watch that one more time just so you know what's coming. Here we go.
On January 3rd of this year, Deobra Redden leapt and tackled Judge Mary Kay Holthus. He was in court for sentencing for a probation violation connected to an attempted battery charge, which stemmed from allegations that he had attacked somebody with a baseball bat the year before.
His brother-in-law.
Moments before the courtroom attack, Redden asked to stay on probation instead of being sent to prison.
Based on my criminal history, I feel that I shouldn't be sent to prison for a second time.
Have you looked at your criminal history?
Holthus did not like his criminal history.
3 felonies, gross, 9 misdemeanors, multiple DVs.
I'm in a better place in my mind, my mental health. I have a support system. I just got hired as a teamster for the union.
After stating his case for leniency, Holthus began to sentence him to prison.
I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court.
According to court documents, Redden punched Judge Holthus in the head and pulled her hair, and he punched a corrections officer multiple times.
The dude right here, he cracked this guy right here, her assistant right here. The dude with the black hair, and he's got on a black suit with a white or light colored undershirt. Cracks me. A very impressive jump, right? I mean, in high school, he had to have been part of the track and field, high jump. That's all I can think of. But
and spit in another person's
watch
face.
the dude start
Court
punching.
marshal, who ran to help Holthus, tripped as he tried to detain Redden, dislocating his shoulder and cutting his forehead, requiring 25 stitches. Redden is now facing a slew of new charges, including attempted murder, battery on a protected person, and battery on an officer. He invoked his right to a speedy trial and has pled not guilty.
He's also pleading not guilty based upon reason of insanity. Just like everybody else, and looking at the video, I thought Mr. Redden was either out of his mind or on drugs at the time of this incident. But after extended discussions with Mr. Redden, Ms. Springer, and other family members, I came to find out that he suffered from severe paranoid schizophrenia.
Redden ended up appearing in front of Holthus one more time to finish the sentencing hearing.
I am making my calendar page from that day an exhibit for the court. Nothing's been changed, indicating the sentence I intended to impose.
Redden was sentenced to 19 to 48 months in prison, but now he could face decades behind bars.
Right, he wasn't trying to give her a hug, that's for sure. No. Yeah, they're idiots. Hey, Miss King, welcome back. The law clerk. He, wow. I mean, I was like, go you, look at you. uh, he was adopted. His birth mom was an addict and used while she was pregnant. You know what? I believe that. They say that the guy is diagnosed with schizophrenia. Um, and that his family said that he had not been taking his medication. He was actually also, um, hold on, let me go back to this tab and share it again. He also had several other charges. He had, I think, 7 or 8 other charges, 6 or 7 other charges, I don't remember, that he pled guilty to, I think, earlier today, but did not plead guilty to the attempted murder charge. And so that is the only charge, I think, that is he's being charged with in this for this trial. And I feel like it's an overcharge. Attempted murder? I just feel like it's I know I know that people can I know that QB, we talked about this yesterday. I just feel like it's an overcharge. Me personally, I feel like it's an overcharge, but I don't know. For the high jump. Yeah. Tanika says the thing I don't like is when they know someone is mentally ill, why don't they get them help? Like Daryl Brooks's mom. You know they shouldn't be out and about unmedicated and unsupervised. Bubbles, I would think they will take more precautions this time, I hope. Ooh, goodness, right? Yeah, I'm sure this time he's going to be he's probably going to have something on like that again. What is on the screen now with the spit guard or whatever, and shackled and cuffed and tied down. Patricia said, I think the judge could have been a little more tactful than saying, I'm going to give you a taste of something else. Right. Should he have done it? No, it's so wrong. But if it was not a judge that he attacked, it would not be attempted murder. Yeah. Yeah, I don't think so either. I don't think so either. Even though he has mental health problems, if he will attack a judge who makes him mad, he could hurt someone else. Absolutely, he could. Absolutely. I mean, I just feel like it's more of a battery charge than attempted murder. But hey, Steph, trying to catch up on this stream, but I miss y'all and love you. And I agree, Patricia. Miss you. We've done a lot. This is the 3rd stream today, Steph. We've been busy bees over here today. I bet he has them stun cuffs. I bet he does too. Probably what they're trying to get to. Battery, you mean? Lesser charges? Whew, I don't know. Callie says, I agree. The attempted murder charge is because it was a judge. Yeah. Stun suit. Surprised they don't have him coming in looking like Hannibal Lecter. Steph says, also, Ryan has spent the last few days clearing off a desk and making me a space to diamond paint at his apartment. Well, he's got to be the one, y'all. Congratulations, Steph. I'm happy for you, ma'am. Can he attend via Zoom? I don't know. Yes, Rogue. Yeah, she was. I just realized Taylor Shabusiness was in the hood and cuffs because she attacked her lawyer. Yeah. It would definitely be a safer option. Hey, Morgana Banana. Is your mouth still numb, ma'am? Is your mouth still numb, honey? Good Lord, are they going to start anytime soon? They're not going to be able to get anything in but opening statements today. I mean, I'm sure that's probably all they were expecting to get in, but... Ooh, somebody in their chat says, I wonder if the judge will be testifying. I mean, I would think that she would have to, right? Or no? QB says, I'm trying to get stun cuff activated on my bingo card. Not going to stop you from eating? Yum. What are you going to have for dinner? Yes, Tanika. Mm-hmm. Yeah, this is in Nevada, so they're on the West Coast time. So it's 2 p.m. going on 2 p.m. for them. $5 p.m. for me. Sore from them stretching your mouth to Alaska. Margaret says my time zone today. Ha ha ha. Yeah, Margaret's on that West Coast time too. Me not so much. Me not so much. All right, I'm looking to see if they have Law and Crime has come back in. Oh, or I could go. Let me go over here on my telephono to Twitter. See if there's anybody live tweeting from there. I don't know. All right. Chosen, but still waiting to sit their butts down, it seems. That's what somebody said in the... Hold on, you guys. Someone said... Day 2 of jury selection in Deobra Redden jury trial began less than an hour ago. One juror dismissed because she did not appreciate prosecutor asking her personal questions, i.e., does she have children, etc. It was a bit uncomfortable because she seemed slightly hostile. Oof. And then 1 minute ago, the same person named Kyle J. Payne on Twitter says many prospective Deobra Redden jurors have seen viral videos of defendant jumping over judge's bench and attacking her, which 8 News Now investigator first disseminated. Some jurors seem to have already been seated, at least for the moment, hoping for openings by end of business Wednesday. So they haven't picked They haven't got their jury picked yet? Well, that's a bummer. Lord have mercy. Maybe tomorrow before they get to openings. Somebody else says the jury is already seated, but I don't know. I don't know, you guys. Ooh, wow, lots of West Coast gals in here. Mm. What, baby? Kiddo's hollering. Oh, Ro was on jury duty once, went to court, never got picked. Wait, what, Margaret? Are you for real? Nonprofit bought Daybell's house and are going to tear it and the outbuildings down. Good. Good. I don't think so, Tanika. I haven't seen anything. They haven't shared anything about the jury stuff. A little one made a cameo. I love when they do the jury selection. I like that a lot. Chigs. Oh my God. Oh, the recipe for eggs. Yes. The cheesy eggs. The way she said eggs too on there, it wasn't eggs, it was eggs. Cheesy eggs. I don't know. According to this person, I don't know if they're live tweeting or if they're posting these tweets after the fact. Says prosecutors asking jurors if they've been involved in or victims of violence. Many have to one degree or another. Would you agree with the general idea that violence can become deadly? Perhaps establishing that the jump could be attempted murder. Ay, ay, ay. Ooh, it's 7 a.m. in Sydney? Wow. Well, you could have eggs for breakfast then. Totally. We had breakfast for dinner last night, though. So we do that every once in a while. Way to go, Margaret. Steph's is playing catch up, but thank you, Jenny. I was mostly joking about the diamond painting thing, making him the one, but it does help. Well, I mean, it does help. Chocolate chip pancakes. Gosh, I haven't had that forever. My favorite way to eat pancakes, which is what I did last night because we had pancakes. Y'all, we had pancakes and fried bologna for dinner last night. Don't be jealous. It was so good. It was so good. But the way that I fix or the way that I make my pancakes is smear peanut butter on top of the pancakes and then your syrup. I love peanut. I can't eat pancakes anyway at all if I don't have peanut butter. It's the only way I can eat it. Spin said, ew. I love, what is it, the peanut butter that grossed you out, or is it the fried bologna that grossed you out, Spins? I love fried bologna. Love it. Love, love, love it. Oh, Callie says allergic to peanuts. No peanut butter for me. Aw. Can you have any, like, almond butter or any sort of nut butter? I love fried bologna too, Morgana. It's my, yum. Fried bologna reminds me of my great granny. Oh, Spins don't like fried bologna. I love it. Mm-hmm. It's so good. Side of bacon and some cold OJ. That sounds good, bro. Y'all, I don't know if we're going to have any opening statements today or not. They were supposed to be ready to roll at 4:30 my time, which was 33 minutes ago. And then their pinned comment on the stream says, we're just waiting for the jury to be seated and then the court will begin broadcasting. But that is not, I mean, come on. Oh. They're going to make me start singing. Bum, 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 bottom. Bum, bum, bottom, bottom, bum, 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 bottom. Bum, 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 bum. Okay. What in the world? I think they're still doing jury selection because the same guy that has been posting these other tweets, this one says 1 minute ago, prosecutor in Deobra Redden trial quizzing a newly seated prospective juror, asking whether she can be fair and whether she has any bumper stickers. She does not, but one did, reading, "Are you this close to Jesus?" A rare, contagious laugh in a criminal courtroom. If you ain't this close to Jesus, you ain't got no business being this close to me in my behind of my car. Patricia, that's been asked before. They ask about bumper sticker stuff, and I think we talked about this before in Chad Daybell. And I think the reason why they come out with that question is because most of the time people who have stickers or bumper stickers, they're usually politically driven, right? And I think it's just a lead-in question. Oh, you have bumper stickers on your car? Tell me what kind of bumper stickers you have. Oh, well, I have a "I hate this person" sticker. Oh, well, I hate this person sticker, or, And it kind of, I think, can give a little bit of a insight into which way they might lean, you know? That's the only thing I can come up with. It may have nothing to do with that. I have no idea, but it's the only thing that makes sense in my head. Margaret says they'd love me. I have a Hello Kitty one. Oh my goodness, your daughter's allergic to strawberries. Nothing with peanuts. Okay. You like it too, Cherie? She said, I love it too. My daddy's mama made it all the time. A bologna birthday cake? What in this world? Sweet cream crusties pancake batter. I would think so, Spence. Spence says, do stickers on the back of my wheelchair count as bumper stickers? Yes, I would think so. Margaret says, Miss King, I'm sorry, says, I had a girl's kick butt sticker and a turtle, but that was my old car. Gail says, I'm over here expanding my Walmart list. Thank you very much. She's put bologna on the list and pancake mix on the list and peanut butter on the list and Krusty's sweet cream pancake mix on the list. Miss King does not like bologna. All right, Tanika, thanks for hanging out. Thank you for hanging out with us with coffee and crime. It's amazing. I had them at a diner before, but then I saw they sold the sweet cream mix at the store, and it's so yummy. That sounds good. Don't forget the chocolate Jif. Margaret's vegetable plate. That's why we're the cafe here. We talk a little bit about crime and a whole lot about food. Bye, Tanika. Be safe out there and go pick up that pretty baby. He's so cute. Bum 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 ba-dum. Ba bum ba ba-dum ba-dum bum. This is dumb. Now I'm getting mad. They're obviously still picking jurors. Like, are they this close to having a full jury? Or do they have a few to go? I think, how many are seated? Oh my God. Mm-mm-mm. Hmm. Mm. Yeah, they're on different time zones. They're on the West Coast. It is 2:11 p.m. in Nevada, or at least here, where that's at. Deobra Redden. Hold on. Sorry, you guys. Okay. Margaret says, we're slow here out west. Yeah, you are. Y'all ain't in no hurry. Nobody's in any hurry out there. Morgana says her one nostril is tingly. She's still numb. Still numb. Hold on, I got a cough. Hold on a minute. Okay. I'm over here looking in 15 different places to see if I can find any updates as to what's going on. But I'm not seeing anything. Nothing. Nothing. Oh, sorry, I just bumped my microphone. Sorry about your ears, Margaret. Well, I mean, Steph, if they get a jury set like very soon, I would think that they would attempt opening statements today because they're on the West Coast, so it's only 2:15 p.m. for them. Ooh, yay, Rogue. Rogue just ordered the big brekkie from the Benedict Cafe. Ooh, Uber's picking it up. Nice. Callie says 4 dead, 2 students, 2 teachers, 9 injured. 14-year-old student, a boy, taken into custody, will be charged as an adult. That's in regards to Georgia. It was a school shooting in Georgia, Gail. Margaret said, I was seated on a jury and we started the openings at 3. Then went home to get started on all the rest of the crap the next day. Well, and I honestly don't feel like that their opening statements are going to be very long either. And I feel like this is going to be a very quick trial. That's just my opinion. I don't know. I mean, how long do you guys think that this trial would even go for? I would think way less than a week. 5 days. That's kind of what I'm thinking. Or less. Okay. A week tops. Yeah. I'm starting to get the yawns. Oh no. Hmm. Okay, 3 minutes ago says seems both. Thank you, huge thank you to Kyle J. Payne. I think this person works for 8 News Now. They've been like live tweeting everything that I've been reading, you guys. Says seems both prosecution and defense in Deobra Redden trial are almost finished questioning prospective jurors, discussing at the bench with the judge, noisemaker on. Judge now excusing certain jurors, hopefully whittling down panel to 14 or so who will sit in judgment of facts. And then 1 minute ago, defendant Deobra Redden at defense table next to his attorney Carl Arnold, dressed sharply in a blue sport coat, very attentive to the jury selection process. It doesn't appear he is taking notes, though his attorney is, while prosecution questions a new potential juror. 41 seconds ago, prosecutor in Deobra Redden trial asking new prospective juror same round of questions. Can you look me in the eye and promise you can be a fair juror? He asks. That person, a part-time mechanic, is sitting next to a part-time librarian. Defense also questions him. Wow. Cherie gives it 5 days also. Callie, it's tough. I'm telling you, I just sent mine to kindergarten this year. And days like today makes me rethink the whole thing. Rogues is not relevant, but with a jump like that, he's a shoo-in for the prison basketball team. Cute. I gotta plug my phone in. It's about to croak. Okay. Thank you guys for being very patient and flexible with me during the stream. It's been 45 minutes and we've sat here and done nothing but chit chat. Thank you very much. I'm keeping up with these live tweets from this person. That is hard stuff. Yeah. I would have too, Callie. I can't even imagine. Can't even imagine. All right, it's been 3 minutes since your last tweet, Kyle J. Payne. Rogue said chatting about breakfast is fun. I was just going to have some cereal, but y'all inspired me. Nice. We talked about the fried bologna and the bacon and the pancakes. There you go. Yum. Deobra Redden. Okay. Inching closer, the last update, inching closer to seating the jury in Deobra Redden trial. Prosecutors are discussing amongst themselves as defense attorneys and Redden seem to be choosing which jurors they'd like to excuse. Perhaps they are done with questioning process, a hectic stage of the process. I'm following this dude on Twitter. And in case you guys would like to follow as well, if you are on Twitter and you need to keep up with information in the area, live tweet source. There you go. You can follow that account on Twitter too if you do so. That was my live tweet source from minute to minute. Waiting on this jury selection process is a bit much. Oh, I love you, Gail. I love you. I know I'm usually not here in the evenings, Steph, which is making me a little bit because in an hour and a half, it's going to, I mean, I gotta, you know. Kiddo's been home from school for like an hour and 24 minutes, and I haven't seen her yet. I'm gonna go see her. Jury selection will take longer than the actual trial, right? Good Lord. This is insane in the membrane. Insane in the brain. Okay. Okay, Kyle Payne on Twitter just said, hold on, let me read it from here. It's easier. Says Deobra Redden appears bigger in person than on video, has an athletic build, in very good shape, which makes sense given the tremendous acrobatic ability he showed when jumping Judge Mary Kay Holthus' bench. Far different appearance than when he was in spit mask and gloves. Oh, wow, Spins. Are you getting ready to leave like soon? I figured you would have been gone earlier today, but I also know how places are when they're like, they say, oh, you're going to be discharged later, like today, and then 25 years later, they finally let you go home. That's how that works. Y'all give me another song to hum. I just got that update from Court TV on my phone, Callie, the one that you gave us in here a while ago about the kids. I sing that one, the Baby Shark one, all the time. Because my kiddo, she loves to watch that stupid. What is that channel? I forget what that's called. There's a channel that she finds on TV, and she watches like all these episodes of Baby Shark. And right now there's like a bunch of Halloween ones, and she thinks that they're hilarious. And I'm like, ugh. Can't remember what it's called. No, not Sprout. It starts with a P. It's like, is it? Hold on, let me look. It's Pink Fong. Pinkfong. Anyway. Okay. Oh, Baby Shark. That's one that'll really get stuck in your head, right? All right. This says from the same Twitter dude. Says all Deobra Redden prospective jurors sitting in silence while parties separately discuss their strategies for jury selection. Oh my God. Judge Susan Johnson has white noise playing in courtrooms so attorneys can caucus privately. Defense huddled around Redden, who is seated. Lord, Lord, Lord. Lord, Lord, Lord. Hey, Donnie, not Wahlberg. Good to see you. Hey, hey, hey. I was talking about you earlier today in one of the other streams, and I kept calling you a he. And I was like, no, Donnie's a girl. But hey, nice to see you back. Best shark movie ever. Steph says, I love that word. Of course you do. We're going to need a bigger boat. We're going to need a bigger boat. Da-dum, 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 da-dum. Dun, 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 dun. You did trick me. I know. No, it's not the same Judge Miss King. No. Well, and I think that would be like a massive, what's the word I'm looking for? The phrase. That would be, Margaret said that would be a very quick trial. Right. No, that's not what I'm thinking of. What's the phrase I'm thinking of? Conflict of interest. There you go. That's it. Callie says, is anyone near where the trial is? If so, can you run on down there and ask them to please hurry it up a little bit? Right? Conflict of interest. Margaret says, I can be there in an hour if I catch a flight. Please do. Please. Can you do me a little favor? Let me go over here. Refresh the Twitter sphere. All right, 1 minute ago. Well, this dude is like pretty good about updates. 1 minute ago, he said 5 marshals in Deobra Redden courtroom, maybe 1 to 2 more than normal. 1 standing adjacent to the Judge Johnson's bench for obvious reasons. Dude just threw shade all over the place. Though he couldn't probably prevent a jump like one that got Redden here in the first place. 1 marshal seated behind Redden with gloves on. Mm. Right, Margaret, run on down there, please. Margaret needs a drink coupon, though. We're going to need a bigger bench. Oh, my God. You guys are killing me today. Rogue comes up with these one-liners. Margaret does it. Ween Baby, she's another one that just flops these one-liners out. Cracks me up. Like that. Love it. Now, if we sit here, a sense of humor, right? The storm, right, Steph? The storm. Ooh, wow, Cherie. I bet it is hot. You got your humor from your dad and your timing from your mom. They're not taking any chances. No. Okay. No updates in the last 3 minutes. The same one. Same update a while ago. Margaret said it was 91 earlier. Now it's 85. Let me get my jacket and pants. Oh, mercy. I will be mad, though. What I was going to say was I'll be really upset if we sit here. We've sat here for an hour and 44 seconds. And I'm going to be really upset if we get to this part. And they're like, okay, we picked our jury. Opening statements tomorrow. I'll say, I don't think so. Y'all need to get your tushes right back in there in that jury box and sit down and let's have opening statements today. Yeah, Kyle is his name. Some Bigfoot show I was watching the other day was talking about portals, and all I could think of was portal potty. I heard somebody say something about portals too, and I can't remember where it was at. But I heard somebody talking about something to do with portals, and I was like, but I can't remember what it was or where I heard it. Then I thought of portal potties too. It's supposed to be hot like this all week long. Oh, that stinks, Cherie. Thank you, Henny. Yeah, make sure you guys put your thumbs up. Give us a thumbs up. We appreciate it. It helps. It helps a lot. Miss King says, so since Daybell's house is sold, I guess the daughter had to move out. I wonder where she is. I know she was sticking up for her dad, but I think she was disrespectful to her mother. I think she was too. Mm-hmm. He probably gave her so long to move out. I don't know. Mm. Mm-mm, 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 mm-mm. Mhm. Waiting, waiting, waiting. Bum, 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 bum. You guys, I'm ready for a nap. I'm ready for a nap, nap. Mm-mm-mm-mm-mm. Waiting, 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 watching, 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 watching. Come on. Come on, come on, come on. We could play a game, right? Rawhide. Whoopsh. Callie said, OMG, my daughter had me up at 4 a.m. because she wanted a bubble bath. Strange little person. God love. Ah. Morgana sounds like a Saw movie, Donnie. Let's play a game. Let's play a game. Mm-mm-mm. Oh my God. Stop yawning, Jenny. Hmm. Mm. Okay. Pick a game, Donnie. Pick a game. Pick a game, Donnie. Pick a game. Margaret says it's only 2:40 out here. I could still take a nap. Yeah, you could. Hey, P. Lola. Found, yes. 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 We've been busy today. I did one stream at 2 Eastern that was about Crystal Rogers. And then I did stream number 2 was about Sarah Boone and her new attorney. And then this one. And we're waiting. We've been sitting here for an hour and 6 minutes and we are still. I did not pee Lola's mom. I didn't. I thought about it, but there was too many other things and I was just like, ugh. I didn't have the emotional chutzpah to stream that one today. I didn't. The Boone stream was good, Donnie. Mhm. Young Thug will be over before this one gets started. You ain't wrong. Mm-mm. Okay, 54 seconds ago. Kyle Payne tweets, court clerk in Deobra Redden trial reading list of prospective jurors being excused. This should result in full jury being seated, approximately 8 to 9 of them filing out of courtroom. Judge Johnson shuffling jurors into seats that might be final 14, all in their permanent seats. That sounds promising. That sounds promising. Hmm. Mm-hmm. We do love Kyle. Thank you, Kyle. Uh-huh. I'm glad you found your way in here, Pilola's mom. Oh, Donnie, cute. Paisley is chasing a butterfly. It's cute. Oh. Look at the picture there. The golden retriever. That's Miss Paisley, right? So cute. So cute. No. Pilola, no. I mean, not unless it's happened in the last few hours. I ain't heard nothing. No, that's not what happened. No. Please, God, no. All right. Judge, okay, this was 1 minute ago. Judge Susan Johnson and clerk now swearing in Deobra Redden jury. Plans to instruct jury on their duties as jurors prior to opening statements. Now admonishing them not to research or discuss case. But first, 15-minute recess. Okay. 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 That would be breaking news, right? Oh, Margaret's Golden is 12. He's a professional nap taker now. So cute. Uh, that judge would lose his cookies if she fired him, right? Mm-hmm. He would. All right. So 15-minute recess. All right. So that's interesting. She probably wanted to talk for 5 hours and he only let her go for 4. So you're fired. All right, you guys, I'm going to take an intermission while they're. Oh, wait. I keep hearing something over there. I think Poppy is moving the door. We have a stream. Yay. Openings will start in 15 minutes, says Law and Crime. So, we have a stream, you guys. Yay! I am going to put some music on. And get, oh, yay, Rogue. Eat your breakfast and enjoy the 15-minute recess. I'm going to take a bit of a recess. P. Lola's mom, he is on trial now for attempted murder of said judge that he attacked. Yeah. Can you believe that? P. Lola's mom? Mm-hmm. Attempted murder is what he's charged with. Yeah. Insane. I think they're crazy pants I think that's a crazy charge, but anyway, that's what they're going for. All right, Callie, I'm going to go take a brief intermission myself, go hug my kid, let my husband know that I have not fallen into a hole in here in the bedroom. Because he's probably like, what is she doing? He's also in trouble for defying the law of gravity. Yeah. Well, he pled guilty to all the other charges that he was charged with for this whatever. But the attempted murder, that's a bit much for me. I mean, if it was a battery charge, okay. But attempted murder, I don't know. People are saying, and some people said it in the chat too, and I kind of agree, that if it would have been anybody other than a judge, it would have been a battery charge, assault and battery or whatever. But yeah, I'm going to go take an intermission for myself for a little bit before they get started. And yeah. So, hold on a minute. What is he talking about now? Wait. While Deobra Redden courts in recess, attorneys arguing issues prior to openings outside presence of the newly seated jury, says viral video will play in entirety, including discussion of defendant's criminal history. Opening should be 25 minutes. State. I don't know what that noise was. I think it was the feed. Opening should be 25 minutes for the state, 10 minutes for the defense. So openings are going to be little bitty, which I didn't expect them to be very long. All right. I know, Margaret, right? I heard that. I was like, ooh. Ugh. All right. I'm going to mute myself, turn my camera off, and I will be back in a few momentos. Oh, wait, Margaret, do you want me to play you some intermission music? Do you want me to play you some intermission music? I can do that if you want. Get the confetti. Okay. Margaret needs music. We'll turn some music on. Okay. I'll be back. I'm back. Hold on, let me turn the music off. I'm back. So I went there and hugged on my baby and turn the volume back up. Use the potty, talk to the husband for a minute. There is this teeny weeny little gnat. Come on, right here. Just right here. So I can, right here. Come on. Anyway, I got me a Diet Sunkissed. Not sponsored. But I got a message today from the teacher. And, hold on. Oh, okay. Hold on. I was really confused for a minute. I was really confused for a second. Hold on a minute. I'm getting a message. A massage. Not a massage, a message, but you know. Anyway, what I was saying was I got, yeah, thank you, QB. She sent me a link real quick. La 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 la. Let me go over there. Grab it. I got my kiddos first little report card, so to speak. Do they even call them that anymore? I don't think so, but okay. Hold on a minute, you guys. I'm going to share this tab instead. I'm going to give my view to Trial TV Live instead of Law and Crime today. You guys, if you don't follow Trial TV Live, go over and give them a subscribe. I just gave them a thumbs up too. They share a lot of live coverage, a lot of live trials and hearings and excuse me. Sorry. I had a little bit of a tickle in my throat, but yeah, they're friends of ours over here and they let us share their live feed and I would love for you guys to go over and give them a subscribe. Thank you. There you go, QB. Thank you very much. Thank you, thank you, thank you. I appreciate that. You had a dance party. Did you guys have a dance party? Mm-hmm. Yeah, me too, Callie. I always watch Law and Crime. If it's not on Law and Crime, then I watch like Court TV is if they don't like sometimes Law and Crime isn't carrying a specific trial, and then like Court TV might have it. And if they don't have it, then usually I have to look for a local station that's got a feed or straight through the court website if I can find it. But Trial TV Live is they're like a new. I don't know how long they've had their channel, but I really like them, and they're good people, good peoples, good peoples, good peoples. So it's live. The volume is up. Okay. Cooking mac and cheese. Wait, what? I'm cooking mac and cheese for my child who requested mac and cheese with chicken nuggets, she calls them. Oh. Oh, yay. Tell them I said thank you, QB. I'll have to go see the Beetlejuice sequel today. Ooh, did that come out today? Husband and I are trying to get caught up on A Quiet Place day one. We started it. We've watched. You know how it is. We can't watch that kind of stuff when the kiddos are up. So we've been trying to watch it a little at a time each night after she goes to bed. And that's been like trying to pull teeth to get that movie watched. But it's been really good so far. Thank you, QB. And thank you for letting me know that they had the stream up. I looked earlier today to see if they had a scheduled this one scheduled or anything, and I didn't see it, but I hadn't checked back since earlier today. So thank you for letting me know. Which one did you watch, Gail? The original, the first movie, or did you watch the sequel or the prequel, which just came out, which is called A Quiet Place Day One? Or First Day or something like that. That's the one we're watching now is the prequel, the Day One, the new one. Okay. It's so good. So far, it's been good, but I haven't seen it all. So. Scream. Gosh. That was a good movie. That was good. But yeah, you guys, though, I got her little report card. First 9 weeks. Why does it say first 9 weeks when it's not even been 9 weeks yet? I'm confused. Maybe this is like a what did it say in the message that she sent? Hold on, let me look. I'll say they ain't been in school for 9 weeks. I know that. Na, 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 na. Ooh, it's all over your TV now? Hey, Trial TV Live. Hey, good to see you. Thanks for coming over and saying, hey. I was telling QB I popped in earlier this morning to see if you guys had this stream for this trial scheduled, and I didn't see it, but you do have another one that looks very interesting. It was the romance novel. No, was she a romance novel person? The woman that killed the husband, but she wrote a book about how to kill your husband or something. That looks very interesting. Was it a romance? Oh, look, there he is. He's got his blue suit on. And look at that dude with the big sunglasses. Wow. She was a writer.
Are we ready to proceed? And you wanted me to read this instruction before you gave your opening.
It needs to be read before we introduce the evidence. I don't know what Mr. Arnold's preference is as to whether it's read before opening.
Well, he looks very
It can be
handsome.
done with your introductory remarks, Your Honor. If you're reading instructions, because it is going to be introduced, like we said, probably off of the first witness. And so we don't want to take the time then to go ahead and, do the Travis construction.
Okay? Okay, I'm gonna go ahead and, let's go ahead and bring the jury in, and I will read it right after I finish my instructions before they get up to do their opening, okay?
Thank you, Your Honor.
Yeah, no cuffs. Eef. Yeah, he's probably got either stun cuffs on or at least ankle cuffs, right? Like they have to keep him from like running. But I would still want. Oof, that's scary. He looks very handsome though. He looks sharp in that suit. And that female judge, I'm sorry, sitting there, I'm like, oh, I hope he's not getting like whew, I hope he's not getting like flashbacks and like, ooh, you know what I mean? I'm gonna start singing "Here Comes the Hot Stepper." I'm sorry. Here comes the hot stepper.
I'll press it, Your Honor.
I hope not, Callie. A little antsy. Yeah, he does look a little antsy. He looks very handsome, though.
Will counsel please stipulate to the presence of the jury?
Yes, sir.
Defense
Right.
does.
You may be seated.
Guys, at the end of the day, we should.
Okay. Okay, ladies and gentlemen, you are admonished. No juror may declare to a fellow juror any fact relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after the jury has retired that he, she, or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose such situation to me through Officer Black in the absence of the other jurors.
Yeah, it's a
This
different
means that
judge.
you learned during the course of this trial, you were acquainted with the facts of this case or the witnesses, and you have not previously told me of this relationship. You must then declare that fact to me. During the course of the trial, the lawyers for both sides are not permitted to converse with members of the jury. These individuals are not being antisocial. They are bound by ethics and the law not to talk
Antisocial.
to you. To do
Oh my
so
God.
might contaminate your verdict. You are admonished additionally, you are not to visit the scene of any of the acts or occurrences made mention of during this trial unless specifically directed to do so by the court. What that also means, when I say no investigations or to visit the scene, I mean you don't just not do it physically. You don't do it by using your handheld devices, your iPads, your phones. You don't Google Earth. You don't do any of those kinds of things. Everything you are going to learn about, you're going to learn about within this courtroom.
That's what I thought,
Ladies
Pilola.
and gentlemen, what I will now say is intended to serve as an introduction to the trial of this case. It is not a substitute for the detailed instructions on the law, which I will give you at the close of this case and before you retire to consider your verdict. This is a criminal case commenced by the state of Nevada, which I may sometimes refer to as the state or the plaintiff, against the defendant, Mr. Redden. The case is based upon an indictment. At this time, or actually a second amended indictment. The clerk will now read the second amended indictment to the ladies and gentlemen of the jury and state the plea of the defendant to that second amended indictment.
District Court, Clark County, Nevada, the state of Nevada plaintiff versus Deobra Redden, defendant, case number C24380-558-1, Department 22, second amended indictment, state of Nevada, county of Clark, the defendant above named, Deobra Redden, accused by the Clark County grand jury of the crime of attempt murder, victim 60 years of age or older, committed at and within the county of Clark, state of Nevada, on or about the 3rd day of January 2024 as follows. Count 1, attempt murder, victim 60 years of age or older, did willfully, unlawfully, feloniously, and with malice aforethought attempt to kill Judge Mary Kay Holthus, who is 60 years of age or older, to wit, during rendition of sentence, and once he knew she was about to sentence him to prison, did leap over defense counsel table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary Kay Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary Kay Holthus by grabbing her, pulling her hair, placing his hands around her throat, and or hitting her on the head by manner and means unknown. Dated this 3rd day of September 2024, Stephen B. Wolfson, Clark County District Attorney, by Elizabeth Mercer, Chief Deputy District Attorney, to which the defendant has pled not guilty to.
Are we being punked?
Please understand that the second amended indictment is simply a charge.
Okay, wait. This is live. I know, you guys, but I gotta stop for just 2 seconds. They literally said Superman style in his charging document stuffs. Who wrote that? Is a good question, P. Lola. It's in the record, says Margaret. Whereas in heretofore he did willingly jump Superman style. I feel like we're being punked. Okay, let's go.
And it is not in any sense evidence of the allegations it contains. The defendant has pled not guilty to the second amended indictment. The state, therefore, has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. As the defendant sits there now, he is not guilty. The purpose of this trial is to determine whether the state will meet that burden. The trial will proceed in the following order. 1, the parties have the opportunity to make opening statements. What is said in opening statement is not evidence. The statements simply serve the purpose of an introduction to the evidence which the party making the statement intends to produce. 2, the state will introduce evidence in support of the indictment. This is called the plaintiff's or the state's case in chief. After the state presents evidence, the defendant may present evidence, but is not obligated to do so. This is the defendant's case in chief. If the defendant presents evidence, the state may present rebuttal evidence. 5, if the state presents rebuttal evidence, the defendant may present surrebuttal evidence. 6, after the evidence, I will instruct you on the applicable law. You must not be concerned with the wisdom of any rule of law stated in these instructions or in the instructions which I will read to you after the evidence, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given you by me. 7, after the instructions on the law are read to you, each party has the opportunity to present a closing argument in support of their case. What is said in closing argument is not evidence, just as what is said in opening statements is not evidence. The arguments are designed to present to you the contentions of the parties as to what the evidence has shown and what inferences may be drawn from the evidence. Your purpose as jurors is to find and determine the facts. Under our system of criminal procedure, you are the sole judge of the facts. You determine the facts from the testimony you hear and the other evidence, including exhibits introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. It is especially important you perform your duty of determining the facts diligently and conscientiously, for ordinarily there is no means of correcting an erroneous determination of facts by the jury. The parties may sometimes present objections to some of the testimony or other evidence. It is the duty of a lawyer to object to evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way against the lawyer who makes objections on behalf of the party he or she represents. At times, I may sustain objections or direct you disregard certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Remember, statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate or agree as to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must not be influenced in any degree by any personal feeling of sympathy for or prejudice against the state or defendant. Both sides are entitled to the same fair and impartial consideration. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, if any, the relation of the witness to the defendant or state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements, and all of the facts and circumstances in evidence. Thus, you may give the testimony of any witness just such weight and value as you believe the testimony of the witness is entitled to receive. There are two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw, heard, or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact from which, if proven, you may infer the existence of a second fact. And I'm going to give you an example of both. You know, it's been pretty hot out there, and I understand it's going to get hotter probably in the next several days before it starts cooling off. I want to take you up to Mount Charleston in the middle of winter, okay? I'm going to take you up there in the evening, and it has just snowed, and you see this beautiful blanket of undisturbed snow. Now, it's pretty well lit because we've got a full moon up there. So you got the full moon, you got this beautiful blanket of undisturbed snow among the trees, and as you're looking at the scene, you happen to see a bunny hop through the snow. That is direct evidence that the bunny was there. You saw it. You saw the bunny hop through the snow. Okay, I'm going to take you back. Full moon, dark sky, shining on this beautiful scene, except there's one difference. The snow is not totally undisturbed. There are bunny tracks already in the snow. You didn't see the bunny there, but it's fresh tracks. You can infer that is circumstantial evidence that the bunny was there. Okay? You may consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. No statement, ruling, remark, or comment which I may make during the course of this trial is intended to indicate my opinion as to how you should decide the case or to influence you in any way in your determination of the facts. At times, I may even ask questions of witnesses. If I do so, it is for the purpose of bringing out matters which I feel should be brought out and not in any way to indicate my opinion about the facts or to indicate the weight I feel you should give to the testimony of the witness.
Y'all in the chat are
I may
killing me.
also find it necessary to admonish the lawyers. And if I do, you should not show prejudice or against the lawyer or his or her client because I found it necessary to admonish him or her. Until this case is submitted to you, you must not discuss it with anyone, even with your fellow jurors. After it is submitted to you, you must discuss it only in the jury room with your fellow jurors. It is important that you keep an open mind and not decide any issue in the case until the entire case has been submitted to you under instructions from me. If you cannot hear a witness, please raise your hand as an indication. I might note we do have earmuffs that can amplify the sound if you are having problems hearing.
Little buddy
And the only
foo-foo.
thing I ask that you do is that when we're not in session, whenever I'm talking to the lawyers privately under the white noise, I'm going to want you to take it off because literally you're going to be able to hear what's going on the tables of the lawyers and you're going to be able to hear what's going on up here and you're not supposed to hear that part. Okay? Also, I plan to have regular bathroom breaks about every hour and a half or so. I try and peg it so I'm not interrupting witnesses or so forth, but sometimes I may do that. So I'll time it to be right in the middle of the session. But I do appreciate nature calls sometimes and you just really, really gotta go. Just raise your hand as an indication and we'll go ahead and take a break right there. Okay? I may during the trial take notes of a witness's testimony. You're not to make any inference from that action. I am required to prepare for legal arguments of counsel during this trial, and for that reason I may take notes. Again, let me remind you that until this case is submitted to you, 1, do not talk to each other or anyone else about it or about anyone who has anything to do with it until the end of the case when you go to the jury room to decide upon your verdict. 2, anyone else means members of your family and your friends. You may tell them you are a juror in a criminal case, but don't tell them anything else about it until after you've been discharged as jurors by me. 3, do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it immediately through Officer Black. 4, do not read any news stories or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. And again, that means you don't use your handheld devices to check me out or the lawyers out on Facebook or anything like that. Everything you will learn about this case, you're going to learn inside this courtroom. A trial is a search for the truth under the rules of law. Therefore, the court will allow members of the jury to ask written questions of any witness called to testify in this case. You are not encouraged to ask questions because that is the responsibility of the lawyers. Nevertheless, if you believe that an important question has not been asked or that an answer needs clarification, you may submit a question. Keep in mind, a witness scheduled to testify later in the trial may be the best person to answer that question. A question may be asked in the following manner. Please write it down and pass the paper to Officer Black. Make sure your juror number is on that piece of paper. Copies will then immediately be made for counsel and me as the presiding judge. I will then privately confer with the lawyers at a convenient time and then decide if the question is appropriate under Nevada law. Also, when you submit a question, make sure that you are submitting it while we are taking in the evidence. That is when the witnesses are testifying and the exhibits are being admitted. If you start asking the questions during opening statement, we can't help you there. And most certainly during closing argument, we will not be able to open up the evidence to have that question answered. Okay? If the question seeks factual information from the witness and is designed to clarify information about the issues in this trial, I, the presiding judge, or the lawyers may question the witness regarding the points raised in the juror question. No emphasis should be placed on the answer to the question merely because the question came from a juror. If a question submitted by a juror is not asked, no adverse inference can be drawn. The question was simply not allowed under the Nevada Rules of Evidence and must be disregarded. Would the either of the parties want the exclusionary rule invoked?
Yes, Your Honor.
Yes, Your Honor.
Okay. If there is anyone present who expects to be called as a witness, please leave the room. Remain available in the hallway and do not discuss your testimony or the testimony of any other witness with anyone except the parties to this lawsuit and their lawyers. Okay? And counsel, do you have any, we talked about the admissibility of exhibits before. I'm going to go ahead and the parties have stipulated to the admission of certain exhibits. That's just to save us some time, so they don't have to lay the foundation for it. States exhibits 1 through 33 and 40 through 61 are admitted. Okay? And I have an instruction to give you. Any evidence that the defendant committed offenses other than that for which he is on trial, if believed, may not be considered by you to prove that he is a person of bad character or to prove that he has a disposition to commit crimes. Such evidence was received to provide context to the events upon which the charge is based, and because it was not possible to omit other relevant evidence and at the same time exclude evidence of other crimes. Should we mark that as court's instruction number A?
Yes, Your Honor.
Are you okay with that, Mr. Arnold?
Yes, Your Honor.
Okay. All right, counsel.
Thank you, Your Honor.
Ooh, they got a PowerPoint and everything.
Give me my microphone. I'm about to turn it on right now.
What in the world? Prosecution is going hard.
I tried to kill a judge today. Those were the defendant's words mere hours after he violently attacked Judge Mary Kay Holthus in this courthouse on January 3rd of 2024 in courtroom 3F.
In accordance with the laws of the state of Nevada.
Is she okay? Hey, radio somebody? Fucking radio somebody!
We're all here today because of that attack. Judge Mary Kay Holthus is here today because of the bravery and intervention of 6 men. Her law clerk, Michael Lasso, Correctional Officer Joseph Cabralda, Chief Deputy District Attorney Jory Scarborough, Chief Deputy District Attorney Richard Scow, Marshal Shane Brandon, the court marshal in Department 18, where this event occurred, and Marshal Ben.
I would have assumed the woman that I heard yelling was the judge, but Pilola says it was his mom, or you think it was his mom. QB said, I think that was his sister. I would have assumed it was the judge, but I couldn't hear what the female was saying. Shell Bell says, how many times will that video be shown during this trial? Ooh. The white-haired dude was no help whatsoever, I know. I think that was his attorney. I don't know, Rogue.
Bachhuber, who is the court marshal in the courtroom next door. On the date of this incident, Judge Mary Kay Holthus was 62 years of age. She had been a judge since 2019. She had a mixed caseload, which meant she heard both civil matters and criminal matters. January 3rd of 2024 was a Wednesday, which meant it was a criminal calendar day. In anticipation of her calendar, she went through her calendar before the calendar actually occurred. Mr. Redden's case was obviously on calendar that day. She reviewed the relevant information pertinent to Mr. Redden's matter, which was on calendar for a motion to quash bench warrant and rendition of sentence, meaning he was supposed to be sentenced in front of her. The information she reviewed consisted of his pre-sentence investigation report. That report provides her important background information about Mr. Redden, but also the facts of the underlying offense. She made some preliminary notes. There was nothing particularly unique about Mr. Redden's case. Then her criminal calendar occurs. When Mr. Redden's case gets called, it's approximately 11:10 in the morning. A little more than halfway through her calendar, which began at 9:30 a.m. When the case gets called, initially, everything is going normal. You'll hear that typically with criminal sentencing, the state gets to argue first. Then a defendant is free to make a statement if he wishes to. In this case, Mr. Redden did. He argued for probation. He presented the court with information that he believed mitigated against a term of incarceration. After Mr. Redden was done, his defense attorney, Cesar Almasi, also made an argument to the court, seeking probation on his behalf. After Mr. Almasi was done, but prior to Judge Mary Kay Holthus having the opportunity to impose the sentence that she believed was appropriate, she made a comment, and that comment was interpreted by many people in the courtroom, including Mr. Redden, as indicating that he was not going to receive probation. After that comment was made, and before she imposed the sentence, Mr. Redden jumped over defense counsel's table, which was approximately 2.5 feet tall and 3 feet deep. He then bolted towards Judge Mary Kay Holthus' judicial bench. As you can see from this picture, the courtroom is set up differently from how this courtroom is set up. There's only one entrance and exit to the judicial bench in that courtroom. He then launched himself 4 feet, more than 4 feet, in the air and tackled Judge Mary Kay Holthus like she was a football player. He then, once was over the bench and made contact with her, pulled her by the hair as hard as he could and yanked her to the ground like she was a rag doll. When she testifies, you'll hear that she remembers being struck in the head, but she doesn't remember how it happened. She doesn't remember if it was an intentional act by the defendant, whether her head hit something, an object nearby during this altercation. But she remembers being jolted and frightened. She was trapped. This is the judicial bench in that courtroom. That entrance is the only entrance to or from where she sits when she presides over her calendar. And the altercation that you saw in the first clip happened right there. She had nowhere to go. She was terrified. She knew that she was no match for his physical strength. So she hid. She hid as far away from Mr. Redden as she possibly could. She crawled into the corner of that bench and waited there until the entire thing was over. When you watch the full video, you'll see that it took approximately 3 to 4 minutes before Mr. Redden was moved from that location. She was so shaken up, you'll hear, that initially she tried to climb that wall that you see in the picture and exit her courtroom where her court clerk sits. That's not an exit. But she did not want to be near Mr. Redden, and Mr. Redden was still in the entrance when he was eventually apprehended. Michael Lasso was the first person to intervene on her behalf because he was situated closest. Michael Lasso is her law clerk. He's been her law clerk for several months now. He'll tell you about what his job duties are as a law clerk. But more than a law clerk, he is also a close family friend of the Holthuses. He has known Judge Mary Kay Holthus his entire life. He was not supposed to be at work that day. Fortunately, he changed his mind and decided to go in. He will tell you that among his many job duties as his law clerk, or as her law clerk, is he sits next to her during the calendars in case something comes up that she needs help with. Thankfully, on this day, he was situated exactly where he needed to be, to her left in that courtroom, as she presided over criminal matters. He was answering emails, performing work, and also paying attention to what was occurring.
She does sound very out of breath. Who said that a while ago? Shell Bell. She sounds really out of breath. I don't know if it's nerves or who knows if she, I don't know, but she sounds out of breath.
On the calendar. He first realized that something was amiss when Judge Holthus made a comment and her marshal moved closer to Mr. Redden. You will hear that when her court marshal moves closer to a defendant who appears out of custody for sentencing, that generally means that defendant is about to be remanded into custody. When the marshal moved closer to Mr. Redden and started to unclasp his handcuffs, they jingled. And then he remembers seeing Mr. Redden bolt over defense counsel's table and across the courtroom. Initially, he believed that perhaps Mr. Redden was trying to exit out of one of these rear exits in the courtroom that staff use. But it became apparent to him pretty quickly that his intended target was Judge Mary Kay Holthus. And when you watch the video, you'll see the surprise, the shock in his eyes as he's watching this occur. He remembers Mr. Redden.
Oh, Callie, his original charge had something to do with like aggravated battery, assault and battery or something against his brother-in-law. I think I read it was his brother-in-law he had taken like a baseball bat to. I thought about that, P. Lola. I'm like, wonder if she's nervous he's going to like get up and attack her. I mean, look at the way he's looking right now. I would be nervous. But the original charge was, it was like a aggravated assault and battery or something. Probation violation for aggravated assault. Yeah. So, and now he's here. Definitely a loose cannon, right?
Launching himself directly at Judge Holthus and knocking her out of her chair with such force that her head hit the tile wall behind the bench. He immediately knew that he needed to take action because he was frightened for her life and he was frightened for his own life. So he lifts Mr. Redden off of Mary Kay Holthus because he's the closest person to her. He got some assistance along the way. And the first person to come to his aid, and Judge Holthus's aid, was Correctional Officer Joseph Giralda. You will hear that on this date, he was assigned to the field services unit at the Clark County Detention Center. That means that he's one of the correctional officers that's responsible for transporting inmates to and from their court hearings. He's also responsible for documenting the outcome of those hearings. So he was seated in the witness stand in that courtroom, which is directly next to the judge, but there's no doorway between the witness stand and the judge's bench. So when he saw the defendant go for Judge Mary Kay Holthus and tackle her, he had to climb over that wall to get to the point where he could assist. When you watch the video where the yellow circle is, that's Officer Cabralda climbing over the wall. At this time, Officer Cabralda was the only correctional officer remaining in the courtroom, because other correctional officers had just done what they call a download, which means moving defendants who are already done with their cases back to the detention center. You will hear that he struggled mightily trying to get control over Mr. Redden. That Mr. Redden resisted both he and Mr. Lasso and everyone else that came to their aid very hard. At some point, Mr. Redden was able to knock him to the ground. At which point, Mr. Lasso and Mr. Scarborough began to work even harder to get him off of Officer Cabralda, because Officer Cabralda was armed back, which could have presented a whole new set of problems.
The dude is trying his best to get him off of him.
Mr. Redden continued to resist, which is why you see Officer Cabralda and Officer Lasso striking him over and over again, because they needed to get him to comply.
Was that attorney just smiling? Did you see that?
He was still struggling to get away from them, struggling to get back to Judge.
Did you just see one of his defense team smiling? I don't know. Look, let me rewind it. Watch his defense attorney's face. You can barely see like half his face, but watch. Right here, watch.
Mr. Redden continued
His
to
ear.
resist.
Look at his face
You
right
see
there.
Officer Cabralda and Officer Lasso striking him over and over again, because
Looked like he
they
was
needed to
smiling
get him to
about
comply,
something.
and he was not getting it. He was still struggling to get away from them, struggling to get back to Judge Holthus. Eventually, they do get him under control. And Officer Cabralda actually uses one of Marshal Shane Brandon's, his actual set of handcuffs. He gets one cuff on Mr. Redden, but Mr. Redden is still resisting. So it takes an additional marshal before they can actually get him into both arms into the cuffs. Chief Deputy District Attorney Jory Scarborough was in the courtroom that day because he had another matter that was on calendar, not Mr. Redden's case. He's assigned to a specialty unit at the Clark County DA's office, the gun crimes unit. And you'll hear that as a specialty team deputy, he makes multiple court appearances in a day, oftentimes. So he arrived at Judge Holthus's department at around 10 a.m. and he was still present, waiting for his case to be called when this broke out. Again, he was partially paying attention, partially not, but he got the gist that Mr. Redden's case was on for sentencing. The state wanted prison time. Mr. Redden wanted probation. And then he figured out that Judge Holthus was not going to give him probation. He remembers, like Mr. Lasso, watching Marshal Shane Brandon move closer to the defendant. He looks down to do something else. And when he looks up, he sees that the defendant has already cleared defense counsel's table and is running full speed and hurling himself at Judge Mary Kay Holthus. Like Mr. Lasso and Officer Cabralda, he immediately knew that he needed to assist. So he went around the witness stand, climbed over the same wall that Officer Cabralda climbed over, and tried to wrap his elbow around Mr. Redden's neck to gain compliance. It obviously didn't work initially. He'll tell you that Mr. Redden was elbowing him repeatedly and trying to buck him off so that he could get back to Judge Holthus. But with the assistance of Chief Deputy Richard Scow and the other people who I've already mentioned, they were ultimately able to get him to comply. You will hear from both Michael Lasso and Jory Scarborough that once Mr. Redden was under control, their first thought was to check on Judge Holthus. When they checked on her, they saw her still curled up in the fetal position underneath her bench. And she looked terrified. She was frightened, disoriented, shaken. And that really struck Mr. Lasso because he's known Ms. Holthus his whole life. And he's always thought of her as a tough cookie. But in that moment, she was scared. Marshal Shane Brandon, as I mentioned earlier, is assigned to Department 18. He's been assigned to that department for approximately 2 years. As the court marshal, he is responsible for maintaining order and safety in the courtroom during calendars. Because of a previous incident that he had where an out-of-custody defendant tried to flee from the courtroom, it became his practice to stand exactly there. The doors behind him that you see in this photograph are the public entrance and exit doors. So he stands there to prevent defendants from fleeing the courtroom if they don't like the outcome. Like Mr. Lasso and Mr. Scarborough, he realized that Judge Holthus was not going to give Mr. Redden probation. So he made his way directly behind Mr. Redden, at which point he intended to handcuff him to remand him into custody. He unclasped his handcuffs, and immediately Mr. Redden bolted across defense counsel table. When you watch the video, you'll see that Mr. Redden hops the table, but Court Marshal Shane Brandon walked around this device that was kind of blocking his path to Judge Holthus. It's called an elmo. And in his pursuit of Mr. Redden, just as he was about to grab his legs, as he was lunging over the bench, he tripped or somehow fell. And when he fell, he sustained a huge gash to his forehead that required 25 stitches. In addition to that gash, he severely injured his shoulder. He didn't initially notice that his shoulder was injured until he stood up in front of Judge Holthus's bench and tried to propel himself over the bench using his arm. At that point, he realized there was something severely wrong with his arm. He had to have shoulder surgery and was placed on light duty until just a few weeks ago, when he returned to full duty. He doesn't remember a whole lot of the incident, not surprising. But when he stood up and realized what was transpiring, even after he couldn't get over the bench because of his injured arm, he walked around the desk where court staff sits to assist as best he could, given the circumstances. He passed his handcuffs off to Officer Cabralda and helped try to restrain Mr. Redden. Eventually, court staff in Department 18 alerted the marshal next door to the emergent situation that was occurring in Department 18. He is the court marshal assigned to courtroom 3E, which is directly to the left of Department 3F, which is where Judge Holthus's courtroom is. Court staff.
The sighing is wearing me out.
They were in session just like Judge Holthus and said, "We need you now. It's an emergency. Please come now." So he walked out one of the rear exits to the courtroom like that, and then walked into the rear exit of the courtroom where these events were unfolding. When he walked in, his entrance into the judge's bench area was blocked because her chair, the law clerk's chair, had all kind of piled up right there. He moved them, and when he got to Mr. Redden had one handcuff in the cuffs and one still loose. He was still resisting.
She sounds
very
like she's
hard,
ran a
and they
marathon.
were struggling to get the cuffs on him. So he took control of the loose arm so that the other individuals could get him in handcuffs. Once the defendant, Mr. Redden, finally calmed down to the point where they felt comfortable relocating him, he was taken to the holding cell just to the side of where the court staff sits. And once he was in the holding cell, Marshal Bachhuber and the other marshals that were down there at this point did what they needed to do to document what had occurred in the courtroom. I think it's somebody on blue jeans. I think it's someone on blue jeans.
Oh, it's somebody on blue jeans, can you use them? Oh, God, what? What?
Somebody put some inappropriate video on there. It was inappropriate.
Okay, we may not be doing blue jeans or Zoom during the hearing, if that's gonna happen.
Yeah.
Okay, I'm sorry, counsel,
It's okay.
and I'm sorry. This has never happened. At least not while
What
I've been
the
out there.
It was the
frick?
first time for everything. Anyways, going back to where I was, Mr. Redden sat in the holding cell outside
What
the
was
courtroom
that?
for approximately an hour or so before Marshal Bachhuber, Marshal Rawlinson, and their lieutenant escorted him to the
I have
Clark
no
County
idea.
Detention Center. You'll hear that it's the
No
court marshal's
clue.
responsibility to book an out-of-custody inmate.
I don't know what that was. Apparently, somebody had like was in there like audio something or other. I have no idea. I thought it's just somebody was talking about blue jeans. I don't know. I have no clue what just occurred.
Who was remanded into custody, which is why they had to do it. So they walked him over to the Clark County Detention Center where he began the booking process. You will hear from Correctional Officer Darren Needham and Correctional Officer Elmis Cabrera that during the booking process, an inmate sees both psych and classification. And that's done for the purposes of determining where to house these individuals. When Mr. Redden was seen by psych on January 3rd of 2024, he reported homicidal ideations. Specifically, the report indicates, in regards to homicidal ideation, patient stated, "Only the judge. She sentenced me to prison." He denied having a plan to harm her. He also denied thoughts or intent to harm officers or other patients, or anyone other than the judge who sent him to prison. Ultimately, because of his expression of homicidal ideations, they determined it would be best to house him in Unit 2C. You will hear that Unit 2C is the unit where they send people with homicidal ideations, among other things. But with regards to his classification in 2C, it was because of his statements. So Officers Darren Meekum and Elmis Cabrera went to transfer release, where the defendant had been waiting for classification. They were tasked with the responsibility of getting him dressed out into his Clark County Detention Center uniform, as well as performing what they refer to as a strip search. You'll see the video of them in the area, but there's no audio. Officer Darren Meacham is the taller individual standing at the front. Officer Cabrera is the individual off to his left. And when they walked into the cell, it was a single person cell. He was by himself. They observed him casually laying on the bench with his hands behind his head. They gave him commands, told him what they were there for, and he spontaneously stated to them, "Sorry I'm moving so slow. I'm kind of sore today. I tried to kill a judge." Those statements that Mr. Redden made and that violent attack against 62-year-old Judge Mary Kay Holthus are the reason that we're all here today. And when the state is done presenting its evidence, we are going to ask that you return a verdict of guilty as to the only charge in this case.
Okay, so good idea, Miss King. I checked the Twitter person, and the Twitter person, I just spit all over my microphone. Sorry. So sorry. They say in the middle of the dramatic, well-paced opening statement at the trial, loud feedback / audio overtook the sound system. Court clerk gasps and says, "I thought I heard her say, 'Oh my God.'" I thought I heard her say that. But it says the court clerk gasps and says that someone played something vulgar over court Zoom, which everyone heard. Very odd. Judge says this has never happened before. So anyway, yeah. So the prosecution, I'm assuming, is done with their opening. Let's see how the defense rolls out. Autobots roll out.
Thank you, Your Honor. Mr. Arnold.
Thank you, Your Honor.
Do you want me to get back on Zoom or no?
Not right now. I want to make sure his presentation's unobstructed.
Okay.
We're good.
May it please the court, counsel, ladies and gentlemen of the jury, thank you for your time and attention. 3.7 seconds. 3.7 seconds. That was when the officer unclaps the handcuffs. My client heard it, turned and looked at him, and made a move for the bench. This all occurred in 3.7 seconds. That was not enough time for Mr. Redden to formulate the intent to kill Judge Holthus. Remember what this case is about. There's one count of attempted murder. And for there to be an attempted murder, there has to be intent to kill. As everything else in life, the story didn't begin on January 13th. This story actually occurred on April 13th, 2023. This is when Mr. Redden was first arrested for what brought him in front of Judge Holthus. And basically, Mr. Redden was arrested for swinging a metal baseball bat at his brother-in-law. What was he charged with? He was charged with assault with a deadly weapon. He was also apprehended by the police, and he was taken into custody. When you're taken into custody, you're supposed to, within 48 hours, stand before a magistrate so they could decide the question of bail or not. Mr. Redden, on April 13th, told the officers that had him in custody that he refused to be transported. So he was just going to stay in custody without these charges being read to him. The following week, they waited some time, continued the matter. On April 20th, 2023, Mr. Redden, he failed to leave his jail cell again. And he says that he wasn't coming to the hearing. They had to continue the hearing. Again, on April 25th, Mr. Redden refused to be transported to the heading. Finally, the Justice Court Judge Jacinto, he did an order that says, by any means necessary, he needs to be present in this courtroom. So on April 26th, the officers got Mr. Redden, and he was present. The judge then, he's handed the charges. The judge asked him if he understood the charges. Mr. Redden didn't even respond to the judge's questions, even though he had a copy of the information, which was assault with a deadly weapon, on his person. And not only did he not answer the judge's questions, he became disruptive in the court proceedings. At this point, again, we have almost a week plus that we see this individual not coming to court. Once he gets to court, he's being disruptive and he's not participating in the court proceedings. At this point, his attorney, which was a public defender, then petitions the court to send him to what's called competency court. Competency court is a whole nother courtroom here in our building. And competency court is for people that do not understand the legal proceedings, are unable to assist their attorneys in their defense, or number three, appear to have some kind of mental condition that prohibits them from acting properly in court. All those things were exhibited by my client, Mr. Redden. He was sent there to be evaluated and see if he can be restored to competency. Restored to competency is basically, we can't try you. We cannot prosecute you under the law since you're not understanding what's going on. You're not displaying courtroom behavior, you're not helping your attorney out. We can't sit here and prosecute you. Right. So basically, he's found on May 23rd, he's sent to Lake Crossing. Lake Crossing is a mental institution here in town. And what they do at Lake Crossing is make sure that you're evaluated to test your competency. Sometimes, people are sent there.
Okay, so I'm going to say it. You got the prosecutor who can't breathe. You got the defense who can't talk. That was mean. I know. And then you have the clerk assistant people back here in the back, the guy and the girl, who are just cutting up, smiling, probably watching the video play on loop. I mean, he's just mispronouncing words, which is petty for me to even say. But anyway, his thoughts aren't organized. Cue the circus music. Okay. I'm just being ugly over here. I shouldn't be ugly. And I'm not like, don't get me wrong, I'm not like making fun of. I mean, I hope to God she ain't had COVID. And I don't know, but anyway, I am still here, Laura. This guy needs Adderall and he should represent Sarah Boone. It's a whole hot mess.
And they have lingering symptoms like they're just making up, acting crazy. Other times, they sit there and evaluate someone and their mental instability is so severe, they just have to stay at Lakes Crossing for an indefinite amount of time because, again, the state can't prosecute you under that incompetency. So in regards to Mr. Redden, he was evaluated and it was determined by Dr. John Paglini, who will be here and he'll testify in regards to this case and in regards to his finding of incompetency. And there are other psychiatrists because there at least has to be two that make that determination. And what they determined was he was incompetent to stand trial. And so he was given a course of medication because his evaluation indicated that during this course of medication that would calm him down, bring him back to earth, bring him to a person that we can work with, that he can go to court, he can understand the proceedings and not be disruptive in court. So Mr. Redden, when you go back to that one, I just want to make the last point that he was at Lakes Crossing for 5 months. He was eventually found by the doctors on October 20th, 2023 to be competent to go ahead and proceed with trial. So exactly 5 months later. Go ahead now, sir. After he returned back to Justice Court, he was in front of Judge Jacinto. He had discussions with his attorney at that time, and they decided that he was going to go ahead and enter into a guilty plea with the state of Nevada. Again, now he's of right mind. He is able to discuss his case with his attorney. As you can see, there was no courtroom outbursts or anything like that. And so much so, the judge released him on November 1st, 2023. He was released from custody. Okay? He returns to back to court, and now this is district court. This is in front of Judge Holthus. And on December 6th, he has no extreme courtroom behavior. He goes ahead and the guilty plea agreement's read to him. He answers a myriad of questions and he pleads guilty to an attempt assault with a deadly weapon. The sentencing was scheduled for January 3rd, 2024. Next slide. What you're going to see through medical records, through the testimony of Dr. Paglini, Mr. Redden did not receive his medication that he had while he was here in Clark County Detention Center. What happened was he gets released and he's given a prescription. That prescription is supposed to be filled at the Mojave Health Center. He calls and you'll hear testimony from Karen Springer. Karen Springer is his foster mother that he stayed with during this time. They made several attempts at appointments, called and attempted to get him in so he could take his medication. However, you'll see through the testimony, he does not get medication and he doesn't get it for 2 months. So from November 1st to 2020, in November 1st, 2023 to January 3rd, 2024, a period of 60 days, he does not have his medication that put him in that state where we saw the appropriate behavior. What you're seeing today, basically, he's under that medication that he had when he was in CCDC. And that's why he's displaying, good decorum, appropriate courtroom behavior. He's not going to wild out, and trust me, I'll tackle him if he tries to, do anything like that. But bottom line, that's not going.
Okay, the fact that you just said you'll tackle him if he tries to do anything like that means you've already thought about what if. You should not have just said that. You should not have just said that. God help. What in this world? Right, Callie? You got to get loud. Dull don't help your client. Yeah. Show a little bit of emotion, But he literally just said, if he tries to do anything, I'll tackle him. Let's rewind it back about 10 seconds. Jesus, take the wheel.
Courtroom behavior. He's not going to wild out, and trust me, I'll tackle him if he tries to, do anything like that. But bottom line, that's not going to happen because he's medicated, he's calm, he understands what the proceedings are and what's going on right now. During this 60 days, Mr. Redden slipped back into his unstable mental state. The same mental state that he had when he was first arrested for assault with a deadly weapon and charged and eventually pled to attempted assault with a deadly weapon. Next. Then we have this unfortunate incident that happened on January 3rd, 2024. One thing I noticed, I looked at this videotape several times from the very beginning to the very end. I know that all the parties involved. A simple question wasn't asked. And I'll explain later as to why it wasn't asked. But no one asked Mr. Redden, did you take your medication today? His attorney didn't ask, the prosecution didn't ask, nor Judge Holthus asked. I'm not saying this is anybody's fault. It simply wasn't done. So he comes into court and nobody knows what his real mental state is during that time. Nobody knows that for 60 days, he's been having paranoid thoughts. Nobody knows that he's been staying at home, not going out into the public, and different other things that were discovered by Dr. Paganini that he'll discuss. Mr. Redden did not intend to.
Oh, but come on. He was just, got in on the Teamsters in the union. He was doing good. He was in a good mental place. Yeah. Laura says, not their responsibility to ask. Shell Bell said, because he needs a babysitter 24/7. There we go.
Kill Judge Holthus. The evidence will show that Judge Holthus, she hurt her head when she struck the wall that was directly behind her, similar to this wall. She also was hurt when she fell on the floor. You'll see pictures. She wasn't significantly bruised. She was bruised, but it wasn't.
The thing for me is, if he is not able to take care of himself and keep his mental faculties in check when he's not medicated, then his family has an obligation. You know? I mean, it's kind of the same. I mean, he has a medical diagnosis. I mean, I haven't heard. I've seen that he has a medical diagnosis of schizophrenic, whatever. But there was another word to that. I don't remember if it was, what is the, it was either one word and then schizophrenic or schizophrenic and then a word after that. I can't remember. But, I, mm, 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 mm. Wouldn't it have been his previous attorney's responsibility to make sure he took his meds that day before court? Doesn't matter if he hurt the judge or not. The fact he jumped on her is enough. Not acceptable. Paranoid. There we go. That's the thing, though. He didn't have his meds for 60. Yeah. $60, right, yeah. Yeah, I mean, he hadn't had his medication for 2 months, right? But it would have been, well, but here's the thing. I mean, QB, I don't know how old this kid is. I mean, he's a young man. He's not a child. He's not even a teenager, but he does he have caregivers? You know? I mean, that's sort of one of those situations where if you have a grown adult who doesn't have anyone to watch over them to make sure that they're being a responsible medicine taking adult, then they don't need to be out in the public. How many times do they try to get the meds? I want info. Because psychosis makes you not want to take your meds, right? But he said he didn't have, they couldn't get them. He's 31, okay. Yeah, his psychiatrist. Seems like he was in a caregiver situation. Well, he was in the, what did they call it? The CC something something. But hey, Kel, good to see you. Good to see you, sweet Kel. All right, let's get back to this. Let's get back. But welcome in, Kel. I'm glad you're here.
Significant bruises, and those were basically on the areas where she fell. She had no cut. She had no strangulation marks on her throat. There will be no evidence that anybody ever that saw Mr. Redden touch her throat. We'll have specific evidence of where his hands were placed right before he was pulled off of Judge Holthus. But again, his actions do not indicate that he was intending to kill Judge Holthus. And again, you always have to go back to intent. That is going to be the big question that you guys are going to have to deal with at closing. Did he have the intent to go ahead and kill? And we are going to submit that the evidence does not show there was any intent to kill Judge Holthus. Thank you.
Okay. Council approach.
Council, approach. All right. So it's been a while since I've said that. Approach. Callie says jumping on a 60-year-old woman could kill her, in my opinion. Yeah, I mean, it could, right? And like QB was talking about in here a couple days ago or yesterday, was talking about the one punch killed. You know what I mean? And that happens. But had this been anybody else, say this would have been somebody who works at the 7-Eleven and he got mad because they didn't have, I don't know, original Slim Jims. They only had the hot and spicy Slim Jims. You know what I'm saying? And then he gets mad and flips out and attacks the person at the 7-Eleven. I don't know. That's just an example. But would that person, if he'd have jumped over the counter on them, would that have been attempted murder? You know? Sidebar.
Okay,
Sidebar
ladies and
City.
gentlemen, the attorneys were, let's say, a lot more efficient than we anticipated. So we're going to go ahead and finish for the day. I need you back here at 1 o'clock. And remember, you're all like brides. We cannot get started until every one of you are here. So during this period of time, you are all admonished not to talk, converse among yourselves or with anyone else on any subject related to the trial. You're not to read, watch, or listen to any report of or commentary on the trial by any medium of information, including without limitation newspapers, television, the internet, and radio, or form or express any opinion on any subject related to the trial until the case is finally submitted to you. And again, no outside experiments, no visiting the scenes of any of the events that you've heard talked about. Don't use your iPads to find out information about this case. Don't read the newspapers. Everything you will learn about in this courtroom. Have a good evening, and we will see you tomorrow at 1 o'clock.
I'm collecting the notebooks.
Okay, so 1 o'clock. That's 4 p.m. for me. So, I want to know who that dude right there is with the sunglasses. Is he another attorney? Who is the dude with the sunglasses? He looked at us. Gail said, he looked at us. He's a very handsome dude. He's a very handsome young man. He looks very sharp in the blue suit. QB said his start with the amount of time it took to start the attack, I thought was good. That was good. Yeah, that was good. I like that. 3.7 seconds or something like that? However, his thing where he says he won't come running through and on top of you, I'll tackle him if he does. That was not a good, you shouldn't have said that. Bodyguard. It's what he looks like. The guy with the sunglasses looks like a bodyguard, but they're not going to have a bodyguard in the courtroom. I mean, he's not a
Has left the
celebrity.
courtroom, and you may be seated. Norma, what exactly, do you know what happened?
I don't know what happened, but when I switched to Zoom, there was a very improper video.
Okay. Counsel, I mean, I want to be able to give the public access to the Zoom and all that. I'm just not, we've called IT about this.
Oh, the court Zoom got P-bombed. The court Zoom link got peen-bombed. Guarantee. Either peen-bombed or P-bombed. Not good. Not good at all. Y'all need to figure out how to y'all need to figure out how to get people in your Zooms, but give them no access to any, like they can't do anything, share anything, say anything, show anything. There's a way to do that. You just got to figure it out. Yeah, I think both bombed, right? P-bombed and peen-bombed for sure.
Yes. Okay. Never had this happen before, but apparently something very inappropriate went on the Zoom system. We cannot have that. And so anybody that wants to see this, definitely you might want to consider being inside the courtroom for that. And then we'll see what we can do on our end so it doesn't happen again. And I apologize again to you for that interruption.
Just for the record, at no point was that broadcast visually to the jury. Although it was audible, we couldn't really tell what it was, in my opinion, but visually it was not in any way broadcast to the jury.
Yeah, I didn't think that it was either. So no, she was the only one. I didn't see it on any of my screens.
Yeah, it only came up on Zoom, which I only had access to it.
Okay. All right. But anyway, we will try and find out what happened there. Okay. Okay. Schedule 1 o'clock tomorrow. We'll have a full day on Friday, half a day on Monday, half a day Tuesday, half a day Wednesday, if we get into Wednesday. Okay.
Thank you, Your Honor.
And start thinking about those jury instructions. Of course, the most important document.
Okay, Callie, were you here earlier, Callie, when they had that audio interruption and you could hear the court clerk say, "Oh my God," and the judge is like, "Oh, this has never happened before." Like somebody broke, like the audio got yeah, okay, you were here. Well, they have recessed for the day. Both the prosecution and the defense finished their opening statements. And so they recessed the jury for the day. They're coming back tomorrow, 1 p.m. West Coast time, which is 4 p.m. East Coast time. But she's like, "Can you tell us what happened now that the jurors are out of the room?" And the court clerk chick basically said there was some inappropriate something or other going on in the courtroom, in the Zoom link. Somebody shared something video wise inappropriate. So, hi Timothy Lunderman. We are ending for the day here. We were streaming the Deobra Redden trial opening statements. So, anyway, I need to rewind it back because I need to get what their court schedule was going to be. She said half days, no court this day, and I need to make sure I get that written down or I will lose track. So, hold on just a minute. Let me Callie, I plan to, yes, ma'am. I'm not sure, Steph. I'm not sure. You may need to be court clerk. I have no clue. I don't know. QB says Thursdays, half day, Friday, full, Monday, Tuesday, Wednesday, half, I believe. Okay. All right. Well, I'll listen to it back and we'll figure that out. But I'm going to go ahead and get on out of here because, yay, I'm glad, Callie. Just make sure you got your notifications turned on. That doesn't necessarily mean anything because 9 times out of 10, people come in here and say, "I didn't get the notification." So, Patricia, hey girl, this one is very interesting. Yes. This showed up in your feed. Okay. Yeah, you were meant to find us then. If you're interested in trials and such as that, true crimey things, Timothy Lunderman. Goodbye, Morgana. I hope your dental work stuff feels better. Yeah, we are a fun bunch. So, yeah, I'll be back to stream that tomorrow afternoon, apparently 4 p.m. East Coast time. As far as daytime streams, I'm not sure what is going on tomorrow. As far as my calendar, editorial calendar wise, I don't really have anything, but that don't mean that something won't pop up. I do want to keep tabs on Crystal Rogers because they're going to be continuing the search tomorrow as well. And yeah, so we'll see. But you guys, thank you so much for hanging out with us all day. 3 streams today. Crazy pants, right? Be here for 4 p.m. Definitely not earlier. Okay, Steph. But yeah, make sure to give the video a thumbs up before you leave. If you're new, I would love for you to subscribe, ring the notification bell, hashtag replay in the comment section down below. If you're watching it on a replay, you guys, this was crazy pants. Crazy town, right? The first hour was nothing. It took forever before they finally got a jury seated, right? Ugh. All right. We will see you guys back tomorrow. Have a fabulous night, everybody. Bye.